Hi, good afternoon and welcome to the State Bar of Michigan Negligence Law Section's Neuroscience and Cognitive Decision-Making seminar. We've got a couple of great speakers lined up for you. And before we do that though, there's a couple of housekeeping matters. Number one, throughout the course of the seminar today, if you have questions, please put them in the question and answer box in Zoom, and we'll get to them at the end of each speaker's section. And if there's something more that you need, we'll be happy to work with you after the seminar as well. If you need CLE credit, please let us know afterwards, and we'll try to get those paperwork for whatever state that you're working with filled out for you. Before I introduce our section chair, Bob Riley, there's some thank yous that are in order. First and foremost, thank you to Madeline Lowry, the section's executive director. There is no one that served on the leadership council of the negligence law section or multiple other organizations, including MDTC, ABOTA, the Ingham County Bar Association, that would ever underestimate or understate the importance of Madeline Lowry in running these organizations. She really keeps the wheels on the bus. She heard, keeping a bunch of trial lawyers coordinated and probate lawyers and estate lawyers coordinated. It must be like herding cats and squirrels at the same time. And it is amazing to me that she does it, and she does it with grace and kindness. And she is just a wonderful, wonderful administrator in person, and we are lucky to call her our executive director and a friend. I'd also like to thank Matt Hinkle. And Matt is the IT guru on Madeline's staff. And he makes these webinars available to us and coordinates the technology, and again, does a wonderful job. I'd now like to turn the chair over to our section chair, Mr. Robert Riley. And Bob has no introduction is necessary to the audience that I see in front of us. But I will say that under Bob's leadership, the section has gone from an excellent section of the State Bar to the premier superlative section. Bob has instituted things like amicus, robust, comprehensive guidelines. He's standardized. He's got a process in place to make sure that there's the preservation of institutional knowledge. The section has never been in better shape, and that's largely due to the efforts of Bob Riley. And I'll now turn the floor over to Bob.
Thank you, Chad. The State Bar Negligence Section Council is a group of energetic, inspired attorneys from both the plaintiff's bar and the defendant's bar in equal numbers. And the group gathers monthly to address matters of importance to us, including matters of civility, integrity, and skill development. Today is part of the skill development function that we have. And I thank Madeline, I thank Matt, I thank our two speakers, David and Graham, all individuals that I consider both valued colleagues and friends. I'd also, of course, like to thank Chad, because our educational programming is done largely under his guidance and direction. And the efforts that you see both today and in other programs are reflective of the significant contributions he makes for us, for you. And I'm glad to have him on board as part of our team. And I assume if we were all together, it would be appropriate to give him a round of applause. Having said that, thanks is good enough for right now. I'd like to give you a quick heads up on some programming that's coming up. On July 11 and 12, we have our Young Lawyers Skill Development Program. We try to keep it to a small group. On the 11th, a small group will assemble in my office in Southfield. And the following night in Grand Rapids, we will assemble in Tom Beam's office in downtown Grand Rapids. Our topic will be mediation, and it will be both detailed and designed for comment, debate, questions, hopefully answers, how to maximize mediation. And both Tom and I occasionally dabble in mediation, and it's a topic we both find very enjoyable. Please consider, particularly for the younger lawyers, joining us in one of these two venues. I'd next like to invite you to consider attending our August 11 event at Tam O'Shanter Country Club. It's a meeting, to be sure, but our focus will be on awards to outstanding individuals as attorneys, as judges, and as mediators. This year, we're pleased to honor Chief Justice Bridget McCormick as our Outstanding Judicial Award recipient. We're also going to recognize Mary Pat Rosen for her achievements as an attorney. And finally, we're going to recognize Jim Rashid for his achievements as a mediator. This event is open to all. There's a registration process, of course, but we would welcome you to attend and join us as we salute these individuals. In addition, the section is working with both the Michigan Association of Justice and Defense Trial Counsel to find a home for the awards for the respected advocate recipients. This is one of the premier awards given by both MAJ and MDTC. And beginning in 2023, there will be a permanent home with us. We will, however, recognize the 2022 recipients, Donna McKenzie, who's the recipient of the MDTC recognition, and Deborah Lujan, who's the recipient of the MAJ recognition as respected advocates. Please feel free to join us as we salute these 5 individuals on August 11. And finally, on October 27 at the Michigan State Educational Building in Troy, Michigan, we will have another presentation that addresses the various needs of our members in terms of neuroscience and the like. It's a dynamic presentation, and we look forward to seeing you there. With that having been done, Chad, I'll turn it back to you.
Thanks, Bob. Our first speaker has been a stalwart of the section, serving through a tenure in the council, all the officer track, and serving as the chair of the section. He is someone who has been, on a personal level, probably the most influential person, not just in my professional life, but in my personal life as well. So I could go on for hours praising him. David Christensen is the founder of Christensen Law in Southfield, along with his wonderful wife, Leslie. They devote their practice to helping injured victims and others in our community, including representing healthcare workers and healthcare providers. He's one of the best trial lawyers that our state has ever seen, including an $18 million verdict in a truck crash case in Wayne County and many other $1 million verdicts. One of the things that you'll note about Dave, if you ever see him in trial, is that he's as comfortable in the courtroom as he is in his living room. He is often cited as being the nicest person in the courtroom. And he has a wonderful demeanor, and his trial presentation is practical and it's very visual. And he's here to share with us some of the keys to success that he's put into place over the years, and some of the things that he has learned to help us all be better trial lawyers. Dave, welcome to the program.
Thank you, Chad. And thank you, Bob, and both as a former chair of the Negligence Section Council, I love seeing what you, Chad, and Bob are doing in leading this council into new areas, and it is vibrant and it's exciting. And I'm hoping that this encourages even more people to get more involved with the Negligence Section Council. It's a tremendous resource. The amicus work that the council does is highly respected by the Supreme Court and occasional courts of appeals, but typically for the Supreme Court, they frequently invite or ask us to write amicus briefs because we're made up of defense and plaintiff side. And so it carries a lot of credibility. And that program has gotten very impressive. Good afternoon, everybody, and thanks for being on this Zoom seminar. I can't tell you how many times I've sat on Zoom seminars in the audience, definitely hundreds over the past couple of years. And what I'm going to be talking about is how to make a winning presentation to a jury, which is your audience. So I'm making this presentation to an audience that I cannot see or hear. I cannot engage with. And what I intend to talk about is how to get your message through to an audience in the most efficient and complete way to get your trial story into your audience's long-term memory so that your trial story is there when they deliberate. There's a lot of resistance that an audience puts up towards getting your information into their brain. On a Zoom seminar, as I know, one of the factors I can be competing with is Googling, because you can Google and have this on and you can be answering email, and that's the best part of being an audience of a Zoom presentation. Problem is, our brains can only handle one language interaction at a time. So when I'm answering email, I'm tuning out the speaker. So I know I'm competing with that. So this is going to be both an educational process, and you'll get to see it at work from time to time, probably. I'm going to share my screen now. Okay. So leveraging the visual cortex. In my effort to be a better trial attorney over the years, I've become a student of learning. And I see my role, and I see the trial lawyer's role, is to educate the jury about my client's trial story. I believe the jury members will vote for the side whose story they believe. So you want to have every jury you face understand, remember, and believe your case story. If you can do this, I'm going to promise you that you never have to lose another trial. I'm going to say that again. If you can do this, you never have to lose another trial. The visual tract is the pathway to memory. You can access the juror's visual tract in ways that allow them to thoroughly understand, to remember, and believe your case story. If they understand and believe your case story, you can win. So how are we going to get there? These road signs are road signs to this presentation today. As I was taught, and probably all of you were taught, we like to lay out our plan ahead of time, tell the jury what we're going to tell them, then tell them what we told them we're going to tell them, and then at the end, tell them what we told them. Repetition is a very important piece of it. But again, when we make a presentation to a jury or any audience, there's a lot of resistance. There's a lot of distractions. In the courtroom, you have a jury. This is all new to them. The language can be strange. They're wondering who's going to pick the kids up at school because darn it, they couldn't get off that jury. There's a lot of competing factors going on in your audience's brain. So you might have them half the time if you're lucky at any given time. So road signs telling them where we are, and then now we're going to change the subject, and now we're going to talk about this next topic. It helps them stay with you, and they must stay with you if they're going to get your story. So we've made the introduction here. Our first stop on this road is going to look at the science. So seeing really is believing, and seeing adds important credibility to your case and to you as the speaker. So look at these bars, and from the top, count how many bars there are. 1, 2, 3, 4, 5, 6, 7. So we all just saw that there's 7 bars there. That's what we see, and that's what we believe. Now go down to the bottom and count the bars again. 1, 2, 3, 4, 5, 6, 7, 8. There's 8 bars. So some people look at this diagram and see 7. Some people look at the diagram and see 8. Seeing is believing. So it's very important that we understand this concept, that people can see the same thing, but understand them differently. The visual cortex in our brain, it's in the occipital lobe, and it processes sensory input that originate from the eyes and other sensory processes, and deposits that data into your working memory, and then hopefully from there into your long-term memory. One way this happens is through methods of visual rhetoric. It's called visual rhetoric. This is a method of using visual imagery to affect people's attitudes, to affect their opinions, and impact their beliefs. Visuals can be used to make an emotional appeal. They can be used to appeal to the audience's logic, or they can appeal in a way that seeks to bolster the credibility or character of a person. In rhetoric, these are called pathos, logos, and ethos. So 80% of learning occurs through the visual cortex. So it's generally broken into 3 general categories. Visual thinking. Visual thinking is metaphors or imagery. Visual learning, that's images used for education or perhaps for design. And visual rhetoric, which can be aesthetics or art. So we assume the audience hears and understands our story, but sometimes we find out that they just didn't get it, and that is no fun for the trial attorney. So committing items to long-term memory requires them to be processed properly first through the sensory, then the working memory, then to long-term memory. So visuals are powerful. That's how we learn 3/4 of all the information that we learn. So with the spoken word, studies show that average people forget or never even hear 95% of what's said. When visual aids buttress the message, audiences can retain 75% of the message. So how can you effectively harness this power in trial? And it boils down to getting your story through to the juror's working memory. Sensory memory is data that comes in through our 5 senses, our eyes, our sense of smell, our sense of touch, taste, and hearing. So we're taking in data constantly, enormous amounts of sensory data. We don't remember it. We remember very little until it becomes significant. But there's a large capacity for this data. It stays with us very, very briefly. The short term or the working memory is where it passes this data on. It has a limited capacity. It's a relatively short-term duration. We can hold 5, 6, 7 things, perhaps at the high end in our working memory for a brief period of time. You know, when I'm trying to log on to a website and it says, we're going to send you a text and a code on your phone. Take that code and plug it into this website and we'll let you in. So I remember those 6 numbers perhaps for a very short period. It's in my working memory. I move it from my phone through my eyes into my working memory and then type it into the website and it's gone. It's gone from my memory. That's working memory. So working memory has a much smaller capacity than your sensory memory. So your sensory memory is like a funnel. It's the wide part of the funnel. The working memory is the neck of the funnel, and that's the roadblock. So the challenge is to move the data through working memory into long-term memory. Long-term memory has a practically unlimited capacity, and it receives the information from working memory, and it can stay there indefinitely. So the challenge is to take your story, get it into the sensory memory of your audience in small enough chunks so that it will feed through the working memory and land in the long-term memory. If you just give people a whole bucket full of information very quickly, they're not going to move it along into their brain. It's just too much. So that's the challenge. So the capacity is the ability to hold and manipulate information while trying to block distraction. That's our challenge. We got to fight the distractions of our audience and make it as easy as possible for them to hear and absorb your story. So you got to pave the road as clear as you can, free of obstructions, free of distractions, and make the data manageable in quantity. The example that I use is this. I love cheesecake. Too much cheesecake. I love it. I'll eat it every night if my wife made that possible. But I can't eat an entire cheesecake all at once. I wish I could. But I can eat an entire cheesecake if it's broken into small enough pieces. I can get that cheesecake down, but it's got to be broken up for me. And I don't like fancy cheesecake with a lot of distractions. I don't like cheesecake with fruit on it. I don't need cheesecake with Oreo cookie crumbles on it. I like just the good old-fashioned yellow cheesecake. I don't need those distractions. So when we're communicating visually, one way that we're going to do this in trial, I believe most people these days will use a PowerPoint. So a PowerPoint slide can be fancy and busy, or a PowerPoint slide can be simple, perhaps one idea with an on-point graphic. That's chunking. That is one slice of cheesecake. And we can feed people one slice of cheesecake at a time, and they'll probably get through the whole cheesecake eventually. Here's some examples of slides that don't accomplish their mission of communicating to the audience. They are too busy. They have too much information. A person could never read this during a presentation. It won't be up there long enough. And if it is, they're not listening to you while they're trying to figure out what your slide says. There's another one, too busy graphically. What is the point? I can't even really detect the message. How to succeed in business. I'm going to suggest that this slide is not going to help you succeed in business. Then here's another one with very distracting colors. It doesn't make a single point, one particular point. It's trying to make 5, and it's not a very workable slide. Okay, now back to our road. We've covered, I think, the science for this presentation, and I'd like to share some examples of accessing visual memory and the visual cortex in some cases that I've had. There was a case against the big box store Menards. this particular Menards, well, they all look the same. Let me start by that. So during this trial, this slide becomes the icon for Menards. And when I want to refer to Menards, the company, and visually, I go to this slide. Bay City is the location that our case involved. And this is just a map to orient people there from Bay City, that this Menards is over by Myers. And between those two stores, everybody knows where this is. They either know Myers or Menards and probably know both. And if they don't know those two, they know Tractor Supply or the Cracker Barrel. So this is where my accident happened. Now, in this case, this is a top view of the Menards story, and it looks very busy, but the point is not for the audience to see all the departments within the store. The point of this slide is to show that Menards is fronted by a road, as all stores are. There's a parking lot, then there's a road, then there's the store. Everybody from the parking lot must walk to the entrance. Then they go through the store and do their shopping, and the cashiers are designed to put the customer at the exit point, and then everybody exits and is dumped out back onto the road and into the parking lot to get their cars. And that's the conscious design of Menards. Because everybody has to cross that road, it needs to be made safe, and cars and drivers need to be warned that there's a lot of pedestrians being dumped out from the store across the road. And there's a lot of pedestrians walking across the road to go in the store. So how do you manage that? How do you communicate to drivers to be careful? This is a pedestrian area. Well, you use a sign is the common way. A big sign that people can see, that's obvious. This is how Walmart does it there in Bay City. This is how Meijer does it in Bay City, but they do it this way at every Meijer store, I think. Put a stop sign right in the middle of the road, hard to miss, protects people. Target uses the same technique, another big box store. The theater at the mall uses the same technique. This is where people are going to be crossing to go in to the movie theaters on the left. And then they come out and they use the same crosswalk. There's a sign there to protect them. Menards, no warnings. There's no signs whatsoever. So no signage. There's people though. The same people are coming in and out of the store, but the cars are not warned. What can happen? Well, the point of this story is that people can get hit. This happened in this particular case. We tell the story of our client visually. She was a 70-something woman, very active and vibrant, had come to Menards to buy a new toilet seat for her house that she was going to install. Instead, she went home with a fractured skull, brain injury, brain bleeds, multiple surgeries, on a ventilator, very limited functioning after this accident. In fact, a little over 2 years later, unfortunately, she died from her injuries. We can tell the story and you can see visually the changes that occurred in her. It's pre-accident. And we usually use a lot of photographs to tell our story. And we call it showing the story. There's a book by that title that is incredibly informative and important to read, I think, Show the Story. So this is a woman that you can glean that she loved her family, was very involved. before and after. Visually, you can see the changes. Now, the next case that I want to discuss with you involves an accident caused by a cement truck that is driving down Telegraph and rear ends a young lady who was just waiting to turn left. This was the iconic picture of the defendant that we used for a number of reasons in the case tactically, but this is the picture that we would refer to when we wanted to refer to McCoy concrete. Simple to outline the location. It's downriver on Telegraph Road. It's an uncontrolled intersection. Young lady was in her car in the left turn lane, coming home from work. She worked nights. This is first thing in the morning. The cement truck driver was on his first run. He had filled up his truck, had a full load, was driving down Telegraph 50 miles an hour, which is the speed limit, looking at his paperwork for his first run of the day. A nice day, but he wasn't looking at the weather. He was looking at his paperwork. The truck compared to the plaintiff's vehicle gives you a nice relative size, and it allows somebody to sense the impact. 75,000 pounds versus 2,800 pounds. This tells a story. The photograph of the car. Interesting, and as big of an advocate as I am of using images, illustrations, visual information to tell the story, you must be discerning. So I am very discerning about what photographs of the crash vehicle I'm going to utilize and give to the jury. Why? Jurors love to study this stuff. They're investigators. And frequently they're looking for something to disprove, I think, what we're saying. So I give them as limited and fine of information that I can. If I gave them the front view of the car, believe it or not, that's what it looked like. This is the side that hit the pole. The truck rear-ended it and drove it into a power pole. So we want to paint a picture of the plaintiff in this case. Very official looking statute. So why would this be in my opening presentation? Well, we're there about the law because the law makes this possible. The jury is there to enforce the law. And I want to give them a little bit of something very authoritative. This is the rear end statute. It looks like a law. It's got numbers and it's got dense language. And I believe that when a jury sees that, they can feel empowered and understand that, yes, the law does allow for this to happen. We use this figure here, again, when we have numerous injuries to communicate, rather than just reading them off a list, we can introduce them. And I could even say a thing or two about each one as I'm introducing them onto this illustration. We can prove that, yes, this really happened. This is an X-ray, and this is what it looks like inside of her cervical spine now, or lumbar spine. Yes, she had a brain injury. These are images from a DTI MRI, which allow us to isolate and objectively show the harm in this woman's brain as depicted on the MRI. Nothing like seeing the image. A little bit of background on Ms. Dorado. And I can let the pictures do the talking, and you as the audience can walk away with a pretty good understanding of what she's like. And she is like this person in the pictures. She's just a joy. People that are fortunate enough to have a lot of certificates or diplomas or awards that make great photographs to share with the jury. They establish credibility. We use boards like this one from her partner at the time, basically with a tiny little quote that we can recite and show to the jury. Another method of using the visual tract is this chronology that we like to use. And what it is a list of every single medical appointment our client has had since the accident occurred, with every provider and a little comment perhaps on what it was that they were doing there, physical therapy, for example, or a surgery. And this adds up in many cases to 8, 9, 10 single space pages of hundreds of appointments. And in an auto accident case, it's our job as a plaintiff to prove that the plaintiff suffered a serious impairment of body function. So this is a visual method of establishing seriousness. This is over several years. They've been going to an appointment 3 times a week, roughly, on average. That's a huge investment. That is a huge change in her life. And so while this document can be used to access information, I can find a date real quick and see what happened on there. It's mostly used just as a visual aid to show to the jury, and we put it into evidence too. A board with a witness, you can put up degrees and so forth to establish credibility or remind the jury of the facts that they learned in the testimony that established the witness's credibility. Or perhaps there's opportunities to destroy credibility. You're wearing the smock today for the video presentation, correct?
Yes, to look professional.
To look professional, although that's not where you work, is it?
At current.
Do they know that you're representing to people that you work there as you testified? Did the sound come through on that? Okay. So that is the slide. Now, finally, in closing, we use the visuals in a little bit of a different way, but in a way to communicate with the jury and have them remember our story and what we said about damages. And we like to put up on either usually it's a projector, and I'm doing this in writing. However, I put up each element of damages, value that, make my suggestion, and whether it's past or future for each element that I'm going to ask for. And so I just unloaded that very quickly. This would take a large part of the closing to cover. Here's another piece of visual source of information to persuade your jury. And more these days, there's surveillance cameras everywhere. There's Ring doorbells everywhere. I went up, learned of an accident, and shortly after it happened out in Montcalm County, and got out there the next day to the intersection where it happened to look for houses that had Ring doorbells on them. They're so widespread. There's tremendous sources of surveillance data that is everywhere, even in neighborhoods these days. This happens to be at Beaumont Hospital, out behind the parking structure. And so this is Beaumont video, which actually tells the whole story of the case in just a few seconds. This car turning here, there it is. This is a different use of a visual. you can see that this car has been reduced to about the size of a dining room table by a big rig that's sitting there. Massive destruction. Horrible thing for anybody to go through. Inside this vehicle was a mother and her 16-year-old son. You assume they perished just by looking at this. It's impossible to fathom how they got out of that alive. So this packs a powerful punch on damages. Now, that was important because, you know, they didn't have any broken bones. They didn't have any major lacerations or cuts. They had some injuries, but were not nearly as injured as this damage would suggest. So if you're trying to prove their damages, this gives you a head start, sort of the flip side of being cursed with a photograph of your client's bumper that has no damage in a rear end accident, which we see plenty of those. This is a case that really lent itself to visual stories. First of all, because there were a lot of photographs. This man was suffered devastating brain injury on the job and was not expected to live. So it was really documented thoroughly right there at the scene. And this is a crane that collapsed on a worker, hit him in the head. And basically, if I go back on the left there, you see two holes, two receptacles that don't have a pin in them. And that's the key to the case here. There was no pin where it was supposed to be. And that allowed this boom on the right to be down laying on, you know, resting on the edge of the truck where it is. That fell and it hit him. This diagram, this schematic tells the story. Requires a few words though to explain it, but it's easy to make it understandable in this way. Now, he had a terrible injury, and I'm showing this only to show you how we overcame the company. The company's argument was, see, he lived about a year. They argued that his death was not a result of the crane collapse. But just looking at this misshapen skull kind of overcomes those arguments, and it's unforgettable. Well, back to our road of this presentation. The next section that I want to explore with you is what other tools do we have to communicate the story visually? I myself do not recommend ever just relying on PowerPoint slides. I think it's important to use a lot of different media. There's butcher paper, there's poster paper, there's boards, moving around, doing different things, keeping the attention of the jury as you're presenting your story is really important. And those are ways that you can keep them with you. Using illustrations to shape your story is really the point. We don't always have great photographs or x-rays or what have you for every accident and every case that we want to try. But you want your story to carry the day. So we all have different sets of life experiences. We have different biases. I like blue, you like red. Those are biases. We have different views of the world. I'm liberal, you're conservative. You know, I'm an optimistic person, you're a skeptic. We're just all different, and we're all okay, just different. So to prove this, though, if you verbally tell a story to 8 other people, you're going to have 7 to 8 different versions of your story come back to you. And many times it doesn't resemble the story that you wanted them to remember. Remember the game of telephone, where we all sit in a circle and whisper a couple of words or a sentence to the person next to us, and they whisper it to their neighbor, and it goes around the circle, and it's funny to see what that sentence turns into. So we're all, we all do this. We hear things, it goes through our brain and our experiences, and it comes out very different many times. We don't want that to happen at trial. You are responsible to shape the image that the jury sees. You're responsible to shape the story so they hear your trial story. That's what you need them to hear, not what their brain's going to come up with, but the story that you want to tell. So here's one. We had a photograph on this one. You can look at this and you can see what happened. There's a guy wire across the sidewalk. There's a scooter leaning against the fence down there in the background, and there's an individual laying on the sidewalk. It tells the story. One way to make sure that that story doesn't get confused is remove things you don't need. You can take that photograph and it doesn't change what the photograph intends to depict, and remove distractions that don't play any role in that photograph. Like that guy wire there on the grass, maybe even that tree. Remove the car. Then you have something that's really an illustration. Here's another illustration. This is that guy wire with people going about their lives, completely unaware of the danger. So if you simplify the scene down to its bare essentials, the silhouettes remove all unnecessary details, but still it conveys the message. It conveys the message that everybody in that neighborhood has to live their life, go about their business with this danger right there. So remember, bite-sized pieces. We're stripping down this illustration to just the necessary pieces. The easier it is to absorb, the more likely it will be recalled. Here's another case that we used actually this illustration in. The worker on the ladder was electrocuted when a high voltage wire from the top of the pole fell off and contacted him. The theory in that case was that we all live, work, and play under a network of highly dangerous charged wires. And that is a fact in neighborhoods that have telephone poles that carry their electricity. We literally live under a web, a network of dangerous wires. And what can happen? Well, you can become electrocuted and instantly your heart stops. You can find on the internet all kinds of video, short video, different pieces of things that you can integrate into your presentation, such as here's a man working. So he's electrocuted. The pathologist says he probably had about 15 seconds of oxygen in his brain to have conscious pain and suffering. So there's all kinds of illustrations all over the internet, and you don't have to pay somebody hundreds or thousands of dollars to put these together for you. You can do it if you just get onto Google and search around. One other thing that you can use through these illustrations is if you have a situation where there's lots of witnesses, maybe 5 different people, each of them has a little piece of the story, a little piece of the puzzle. And you can use an illustration that puts all of those pieces together in one cogent story, and you can do it right on one board. Make it very understandable, making it easy, little bite-sized pieces. Using video is especially effective as a device to impeach a witness. Videotaping your discovery depositions is a small price to pay for a pot of gold from time to time. And
I think they were doing what they needed to do. Often we send people to rehab after tracheostomies are performed so they can take care of the tracheostomy.
So I don't give you any context for this, but there's no wiggling out of deposition testimony that directly contradicts the trial testimony. There's just no getting out of that, taking it out of context. Okay, another visual, very powerful visual tool is to use timelines. And sometimes they're hard to conceive of, especially when there's a lot of time that's gone by. There's a couple of principles to keep in mind. If you have a long period of time and you want to present it as it seeming to be a shorter period of time, just reduce the number of points that you use on your timeline. Now, this depicts about 12 years, but it appears to be a shorter timeline. If you want something to seem longer, then just put a lot more dates in there. You can even put like every day for several years and have 1,000 points on your timeline. It has a visual impact in how the audience interprets the length of time, as well as the information you're putting up there. It's key. This helps a jury keep organized in their mind this whole story, because the whole story is new to them. The trial lawyer's been living with it for years. We consider, and we too often walk in and tell the story once in opening, and we expect everybody to have it, and they don't. Trust me, they don't. I've had many of them tell me, I didn't get your case, Dave, and that was always a sad result. Another timeline you can use, if a situation's gone on for many years, you can express to the jury, like, that's a long time. You know, that was back when Obama was elected in 2008, or any one of these events that are depicted here. That was so long ago. I think the Tigers were in the World Series when that happened. That was when the last pre-existing instance of back pain was. And where are we today? It's been a long time since Tigers were in the World Series. It conveys a long sense of time. Graphs or charts. This is another way of graphically conveying information. Many times the actual numbers aren't even that relevant unless it's really something very scientific or economic that you're trying to convey. But this board has numbers on it and so forth. But this is really showing the accumulated costs of various medical events and relative costs. So it's the length of lines that are important, and I can describe that. And it's very easy to understand just graphically. You don't even need the numbers that are on it. Diagrams, you can draw whatever diagram is going to help out your case and use it. We don't see enough of this. Now, they need to be simple. Does anybody understand this diagram? The formulas. It's pretty difficult, probably not very effective. It could be simplified down so people understand what happened. One of the greatest resources that's available to us, and it's free, is Google Earth. So if you have a case where location is important, whether the actual location or address is important, or what does it look like there, maybe that's important. Maybe it's all important. Google Earth has every view conceivable in the world, including street level pictures. This is the most dangerous intersection in Michigan. If we were live, I'd ask you to tell me which one it is, but we're not live. We're not in person, so I can't do that. This is 18.5 mile in Van Dyke in Sterling Heights. There's an average of 5 crashes every 2 weeks. So what would you expect to see there? A law office. So not really. I took and put that in the picture because I thought it'd be funny. But that's how easy it is. Not that you want to falsify pictures. It's just very easy to work with images from the internet. And I am not an expert in this by any means. A couple other ways of graphically communicating information, again, to get it through the working memory into the long-term memory. Here's one that a plaintiff uses. The scales of justice. Who's carried the burden of proof? Well, without paying attention to what any of them said, you would at first blush say, the one on the left has more evidence. This is a great way of it's visual rhetoric. Okay, other media, I touched on it. Butcher paper, large pads. For years, all I ever used was large pads. And by the end of the trial, I'd have 2 of those pads completely full. Sometimes there's so many that it would pull my easel over. It actually happened routinely. The greatest, I think, trial lawyer device to come around in a long, long time is the Ipivo. This gives you free rein to create visual information for the jury in real time, in trial. It's just a little more than $100. It's basically a document projector that just sits anywhere you put it. It's as simple as anything can be. And you can use it, and you can use it as you're crossing a witness, for example. You want to organize the road signs for the jury of where you're going. You do it in real time. And you can create your guidelines like this. I took this from Mark Lanier, one of the greatest. He's about to cross an expert witness, testified all day the previous day. He comes in the morning and says, "Doctor, we're going to cover 3 areas: who you are, then what you know, and then finally, we're going to get to the truth." And the jury has these road signs. And as well, you can write down what they say, take notes of what you think is important. And it's going right on the screen in real time. The Ipivo, I-P-E-V-O. Okay, we're at the end of my road. In order to present a memorable and understandable case, you need to make it as easy as humanly possible to understand and recall your story. To do this, first show them a roadmap. Tell them where you're going. Then tell them at each signpost where you're taking them. At that point, and in the end, tell them again what you told them. Along the way, use as many visuals as you can. I've used about 125 slides in this presentation of 45 minutes. Keep them simple. A simple sentence expressing one idea per slide with one graphic that is on point. Tell the story with words and images. People are used to seeing stories played to them visually on TV, YouTube, TV. They're primed for this. Use it. The internet provides a vast and endless library of material for you to use. This will make your trial story the most believable and memorable and will win the day. And if you cannot construct a compelling trial story, then that's the case you settle. So thank you for listening today, and thank you, Chad and Bob.
Thank you, David. We do have a question from our friend Andrew Satmerstein. He asked about the computer programs, the actual software that you're using. You mentioned PowerPoint. Tell us about the programs that you're using to either create the timelines or the graphics that you're using.
Honestly, nothing fancy. I don't have any software besides PowerPoint to put this together. Our office, that's not true. We have the Adobe Creative Suite, which includes Photoshop, which allows the creation of virtually any graphic you can dream up.
Can it make me look like Brad Pitt or George Clooney?
You already do, Chad. Can't improve on that.
Well, thank you, Dave. A quick question for the audience. We're at about 3 o'clock. And if Dave's around later this afternoon, if there's other questions, there'll be some question and answer session at the end. We'll take a quick poll. If people want to take a 5-minute break, we can go ahead and do that before Graham Ward starts with his program. And if not, we'll just launch on. So if there's should be a break time poll up there. Does the audience want to take a 5-minute break before we go on, or just continue? And we'll give everyone a chance to do that. And Matt Hinkle, through the wonders of technology, will give us the results. In the meantime, I do want to touch back for a moment on our opening. We had the picture of the Pride Rainbow up. It is Pride Month, and diversity and inclusion matters. And I'm proud that the negligence law section has taken an active role in trying to promote diversity and inclusion in our profession. There are some members of the council that have taken a special role, Deb Freed and Donna McKenzie, and a member of the judiciary, Judge Amy Ronayne Krause from the Michigan Court of Appeals. The three of them are putting together a special program which focuses on number one, professionalism, but also on civility and the special needs and challenges that are facing women lawyers in our section, and also the wellness issues that are confronting many lawyers, especially young working mothers. And so that'll be a great summit. We hope to have that for you later this fall. And that will also cover other issues, including implicit bias. And so hopefully all of you can attend, and that'll be a live event. We're trying to arrange that for our MSU Troy meeting room. All right, Matt, what was the answer on the break? In favor of a break. All right, well, we're going to take a, well, 3:02, so we'll be back in 8 minutes at 10 minutes after 3, if that's okay. So 3:10, and we'll see you all then.
I got an idea.
Yeah, well, before I introduce officially Professor Graham Ward, who is a repeat speaker for the section, I do want to take just a minute and fill our audience in on some of the events that happened this week, because it's been really great. Number one, just yesterday, one of our active section members, Seema Patel, was sworn in officially, her investiture ceremony as a judge of the Michigan Court of Appeals. Judge Patel has been a frequent speaker and participant for our section, and a wonderful friend of the section. So we very much appreciate and congratulate her. We know she's going to be just as fantastic of a judge as she was an appellate lawyer. I'd also like to take a moment and congratulate again Deborah Freed. Deb Freed is on our leadership council. She's really a central core member of our leadership council. And any organization, as you go, the pyramid model, there's, they say there's 5% of people that do 95% of the work. Well, Deb Freed is on the 1% that does 99% of the work. There's so much weight that she carries on her shoulders, and she does so much for this organization. It's incredible. And she is the leading charge behind the Women's Summit, and she will also be heading our Civility Matters initiative. Deb was just last week very well deservedly recognized with the section's highest honor, the Clarence Sherwin Schreier Award for lifetime achievement and excellence in the practice of law and promotion of our civil justice system. And that is an incredibly well-deserved award, which of course was very fitting, given that in the same week she also received what may be a record-breaking civil rights verdict on behalf of an injured state trooper who was then discriminated against. Deb Freed, congratulations. With that, we'll now resume our programming. Sorry, we have to turn something off here. I apologize. We'll continue with our program with Professor Graham Ward. Graham came to his current position as a director of conflict resolution at Thomas M. Cooley Law School after a career as a trial lawyer. As you may have heard, he's tried over 30 cases, major cases to verdict. He's represented large corporations, he's represented individuals. He has sought justice in a variety of venues. I think that there's some things that really stand out about Graham. Number one is the number of professional and personal lives that he's impacted. He's served as a mentor. If I gave you the list of lawyers that came out of the Dice Sweeney firm under Graham's tutelage, it would be remarkable. Lawyers, great trial lawyers. Well, you met Bob Riley, Rick Boothman, Dale Hebert. The list goes on. In fact, we were at a program this past weekend for a BOTA in the section where a group of Dice Sweeney alums were all together, and it was literally a who's who of Michigan negligence law. And so that's really a rewarding and fitting notion to how impactful Graham has been to our profession. I first met Graham not through his work at Dice Sweeney, but after he had moved on to Cooley Law School, where I also serve as an adjunct professor. I teach the medical malpractice course, and Graham has been kind enough to come almost every term to speak to my students and be a guest lecturer during the course of the term. And he's very well received. The reason that we do that, by the way, is when I started asking students at the beginning of my own teaching career, who their favorite law professors were, who were the best teachers, and why? Overwhelmingly, what I heard was Graham Ward. Why? Because he made things personal. He made things understandable. He put things into the context of students' existing knowledge, and he helped them transition from ordinary folks to ordinary folks that could think like lawyers, and then back to ordinary folks again. He made people realize not just the what, but the why, and that is a really fitting model. Well, with that, Graham, I will turn the presentation over to you, and I'll be sharing your presentation now.
Just a couple of things. Chad, I'm going to add to that name. Jack Vandermeer, my best friend. Ron DeNardis, Dave Ghetto, Bob Foster. I'll tell you, it was quite the crew. And I am going to start now with a few comments of a general nature, and then Chad is going to help me out with some PowerPoints that will provide me with a model that I'm going to work with as we go through this. The teacher in me told Dave Christensen a few minutes ago that I had 5 pages of notes from his presentation, and I really feel the need to put them into a summary and then ship them to all of you. But I'm not going to do that. I'm going to talk a little bit more about our practice and the stuff that we do, and something that really has gotten my interest. It's behavioral law. It is the way people react. What influences people? How do we make decisions? You know, that speaks to me. And one of the problems with that is that we have a number of impediments to good decision making. They're generally referred to as biases. And I'm going to talk with you about a number of them. I'm going to start by telling you a couple of stories that I will shorten up. They're stories that I tell in my course on decision process. I'm going to shorten them up just to demonstrate how some of these biases impacted real life decisions. Every once in a while, we try and do some of that real life stuff. One last comment before I tell those stories. Mr. Christensen, I want to thank you for showing me all those pictures. To refresh my recollection of all of the horrible accidents involving lowboy trailers that jackknifed and took the top off of a Toyota. 5 electrocution cases that always take place during storm work because crews are called in from all over the country and are being pushed through 16-hour days. And I don't want to forget the crane case, which reminded me of some of those other injuries. I thought 20 years would be enough to get them out of my mind. When I wake up at 3 o'clock this morning crying, and I'm going to have my wife call you to explain how those things can impact us all. So if I can, Chad, can we go to the second slide? Very good. And short introduction. There are 5 or 6 books that anybody can read to start picking up on a lot of this stuff, but we don't have time for any of that. One of the most important books, though, is called Thinking Fast and Thinking Slow. Kahneman and Tversky, super smart guys. And one of the things you learn about decision process is that we make decisions through 2 separate systems. How unique. We call them System 1 and System 2. System 1 is intuitive. It's the sort of thing that tells you when you've been driving an automobile for X number of years and you have the right of way on a 50-mile-an-hour street, but you know damn well the person on the cross street to the right, that car is not slowing down enough. You know that. You don't need anybody to tell you. These are models that exist within our minds. They allow us to make these snap decisions. And 90% of the time or 95% of the time, they help us make these everyday decisions quickly, almost automatically, often unconsciously. There's a term used, heuristics, that describe these mental models. And without going again into all the different types of heuristics, a couple of them are availability, that which comes to mind, and representativeness. What do I see that looks like other things I have seen in my mind? And, we make decisions that way. And 99% of the time, those are good decisions. The other system too, it's slow, it's conscious, it takes a lot of energy. It's thoughtful and reflective. It is not the kind of decision making that you exercise when you're involved in a trial and somebody has just about finished a question that you think is objectionable. You don't have time for a system 2 analysis. You are up on your feet before the question has been completed. And in many instances, the judge already knows why you're making that objection. That's a System 1 behavior. But in order to be able to do that, you have to have these experiences and you have to have the mental models. And one thing that does trouble me about a lot of this is that for the last 4 or 5 years for sure, we've been hovering around 1% as the number of cases that get tried. And that's really not a lot. And I don't think it's enough to give most of us lawyers, particularly negligence lawyers, all of the mental models that we would like to have when we find ourselves in these situations where we have to make these decisions. Now, I told you I was going to tell you a couple of stories. They're illustrative of the real world appearance and consequences of some of the biases that we know exist. And before I do that, I want to just segue for a second and talk about stories in general. All of you in law school and at times thereafter have heard the expression, the best story wins. And I would like to expand upon that just for a second and use all of that wonderful material that Dave Christensen just put in front of you. The best story works in a chronology. It fits into everything that's been said in the opening statement, where we know that a very large percentage of jurors, they don't decide the case, but they develop impressions. And those impressions cannot be put aside. They need to see that chronology as well as hear it during the opening statement. In the course of the evidentiary proofs, it's a demonstrative exhibit during opening, during the proofs, you've got it in again, and then they're going to see it again in your closing argument. And the repetition helps. When you've seen something for the third or fourth time, it's a lot more likely to stay with you. The ability to do this is what makes the story so much more plausible. Some people who study from a behavioral point of view will tell you that the best story wins because it is the most plausible, and then in the next breath they will tell you that it may not be the most probable. Those people are very statistically oriented. I think for our purposes, and since the purpose of trying cases is to win and not necessarily find truth, we'll accept that there is a good correlation between winning and truth, but we all know it's not one-to-one. So the importance of these exhibits, the repetition, and how they work into the story. David talked to you about timelines. A year and a half ago in one of my courses, I was telling students, you start watching what we're going to hear about January 6th and see how the timelines are put together. And those timelines are not only going to make the story more understandable, but they're going to help you see who's lying. Or maybe people who just have gotten themselves and allowed themselves to get confused. So let me tell you two stories. First about climbing Mount Everest. Second is about the explosion of the Space Shuttle Challenger. We're going to go back to the mid-1990s. And on that particular day, event, Summit Day, a number of people, climbers, died, including two very experienced guides who had reached the summit a number of times before. They died because they stayed with other people trying to help them, and a number of them also died. Every one of those people had paid roughly $70,000 back in the mid-1990s for the privilege of trying to climb Mount Everest. That is sometimes referred to as the sunk cost bias. When you've put a lot into an effort, and in this case, it's not just the money, but it was also time. You don't arrive on a Friday and start your climb on Saturday morning. You've got to be acclimated for close to 2, 3, 4 weeks. One of the participants was a cardiologist. I can only imagine the kind of billings that were lost, that I guess you would add to his sunk costs. But we had this, number one, a lot of money had been put into the process itself. Another bias that was discovered was what's known as the recency effect. People have a tendency to pay more attention to that which is more recent, more currently available in our own minds, rather than look back throughout the entire history of climbing Mount Everest. In this particular case, nobody had died on the mountain for 3 years, and that's good. They also had the recency effect of good weather on summit day in those preceding years. And because of that, and because the guides learn more and more and become more sophisticated at how to conquer Mount Everest, they generated a certain amount of what we would call the overconfidence bias. Let me tell you what happened. The weather was shitty. There was a storm. They had set a rule. They made their own rule. If you haven't made the summit by 2 p.m., you turn around and go back down because it's very hard to climb down the mountain in the dark. They made that rule. They all understood the reason for the rule, and they all violated the rule. One person said, I've gone too far. I've gotten this far. I can't give up. One of the guides had made a statement, talk about the overconfidence bias. He had said, we've built a yellow brick road to the top. I think it was the same guide who said to a fellow who was struggling, come on, you can do it. I've got people almost as pathetic as you to the top of the mountain. You want a visual representation? We saw some signs. We saw some signs that Mr. Christensen had put out, warning people, almost becoming a mental model for people that shop at Meijer's and go to grocery stores, go to movie theaters, etc. Maybe even to the extent that they thought they were there when they were at Menards, or maybe they didn't look for them because they're just so common. The signs that warned people about problems climbing Mount Everest were dead bodies. I don't know what color they were, whether they met the National Safety Code's requirements for color and size and the conveyance of a message. But if you were looking for a message that cautioned you about the danger implicit in climbing Mount Everest, dead bodies are a real good sign. In spite of all of this, experienced climbers, in spite of the skills that they all had, 5 people died on that particular climb. Signs of bias: overconfidence, recency effect, sunk costs. Now let's talk just for a minute about Challenger. For those of you that don't remember when it happened, this was the first time that a space shuttle had not experienced a perfect flight. And about a minute and a half into the flight, hot gases escaped from the seals, the O-ring seals on the solid rocket boosters, and that combined with all the fuel around, etc., created a great big explosion. In hindsight, we found out that these O-rings, which sealed parts of the boosters together, had been failing. In fact, they had deteriorated over some period of time, but nothing blew up. Nobody died. Replace the O-ring, everybody's fat and happy. On the night of the safety of flight meeting that takes place beforehand, an engineer, Roger Bourgelat, was concerned that cold temperatures played a role in this O-ring deterioration. He brought it up at the safety of flight meeting. But because they had seen some of this before and nothing bad had ever happened, there was a form of confirmation bias that existed within that group where they recognized it. They didn't think it was a big deal. In hindsight, it was the coldest launch ever. And just before the launch, you get a chance to see all of the ice that exists on that platform because of the need to make things even cooler. So what did we see in that situation? What we saw were examples of confirmation bias, groupthink, and the recency effect. And we also saw some stuff that was a sign of overconfidence, because one person said, we're going to make flying on the space shuttle the same as taking a 737 to Disney World. One of the astronauts later was quoted as saying, well, if that's the case, ain't many people going to be flying to Disney World. These biases are real. They exist. I'm going to introduce them to you now in the next slide, which I'm going to ask my friend Chad to pull up for us. And what I want you to understand is this is not an exhaustive list. And some of the words that are used or the terms that are used are different than other people describing these biases. But know this, it's very important. I have these biases, you have these biases, judges have these biases, jurors have these biases. We could talk for an hour about any one of them, but I'd like to introduce you to these 8 and probably spend more time on a few of them than I would on others. The anchoring bias. You can read on that. People are over reliant upon the first piece of information they get. You may want to ask yourselves questions on the plaintiff side about where that first number, where that first demand should be. And the same question on the defense side about the offer. There's a built-in expectation that each side is going to move off those numbers. How much is an unknown factor until the positional bargaining ends and people say yes to some magic number. But the first number serves as an anchor. There was a time in my life when I thought that asking for too much was a sign of a lack of sophistication or a true understanding of what the real settlement range value of a case should be. I'm not so sure if I believe that any longer. I'm about to say there's no number that's too much. And then I want to pull back and not say that to you. Let me make an addition, though, to this portion about the anchoring bias and the first number you hear. People who have studied this will take a group of people, not a group of law students, because I've managed to screw this up every time I try it with my own students, but you take a representative group of people large enough to be a statistical sample, and you ask them this question: what are the last 3 digits of your cell phone number? They write it down. People talk for a couple seconds, and then the leader of this exercise says, do you think Attila the Hun died before or after 500 BCE? Gives people 5 seconds to write down before or after. The finding is that people who have low last 3 digits of their cell phone number are more likely to think poor old Attila hit the bucket before 500 BCE. Whereas people that have cell phones that end in 989 are more likely to say that Attila died afterwards. You don't want to have a highly educated group of people that might have a better mental model, a better availability about when the Roman Empire was at its peak, et cetera, et cetera. But think about that just for a minute. The ability to bias a decision, the date of the death of Attila, impacted by something as irrelevant as the last 3 digits of your cell phone number. That has the potential to be abused in the work that we do. I'm going to skip over the second one, availability, just for a second. It is a heuristic. It has a lot to do with that system 1 type of thinking, but I want to come back to it. The third bias here is the bandwagon effect, and you see the word groupthink. It is clear that in any group of people, and when I say a group of people, what should be in your mind is a jury. Within any group of people, you're going to have someone who's more influential than others, and for different reasons. You know, someone may be clearly the most educated or the most successful, maybe the tallest, maybe the best looking. And as ridiculous as height and societal norms of what's good looking are, people like that do exert more influence than other members of the group. And that's one of the very negative features of groupthink. There's probably someone in that jury who will keep their mouth shut or participate in an absolute minimal way, and for reasons that are known entirely to them. It's just easier to go along in order to get along. The next one that's spoken here is blind spot bias, which I find kind of interesting. A lot of us refuse to recognize that we are influenced by these many biases. If you've ever had a chance to see a lecture by Professor Kimberly Papillon, the two biggest questions in your mind was she a lawyer first or a neuroscientist first? And she knows so much about each that it's almost impossible to tell accurately which she became first. But she has a wonderful study to demonstrate implicit bias. She takes 3 rap sheets, identical rap sheets in histories. One person to be sentenced is white, one person is a light-skinned African-American, the third one is a dark-skinned African-American. All the judges, she teaches at the National Judicial College. All the judges, of course, know they aren't biased. And yet, time after time, the white guy gets 5 years, the light-skinned African-American gets 10, and the dark-skinned gets 20 to life. We have to understand the implicit nature of these biases. The next one on our list here is choice supportive bias. It says when you make a decision, you kind of stick with it, or you feel positive about it. There's a term in behavioral psychology called bounded rationality. And bounded rationality basically says that there's always too much information in the world for us to acquire it and assimilate it all. And secondly, there's always a time factor. No matter how much time they give you for discovery, it's never enough, right? And so you invariably find yourself with less time than you would like. And we make decisions, therefore, based upon less than total information and because of the press of time. And generally speaking, those decisions are, quote, good enough. A term that's also used to describe them is satisficing. Satisficing. In one of the really seminal books on problem solving and negotiation, getting to yes, there are 4 steps. Separate the people from the problem, focus upon interest, that is needs over wants, develop options, and then tie your resolutions to something that's objective. That third one is the one that speaks to me. And what I'm suggesting is probably a little bit more appropriate in other types of conflict, business decisions, maybe decisions that would have to do with employment relations matters or how to solve an employment problem. But one of the things that you will find is that people will, by the time they get to the second or the third option that's being proposed, they'll be evaluating them. And when 2 or 3 people get to that third one and their heads pop up, they've made a decision. You know, they found something that's good enough. But by not exhausting the generation of options, they have made a decision that's good enough, but not as good as it might have been. They've left value on the table. The clustering illusion. Nobody likes to think that a lot of stuff in the world is random. People who play Keno will sit there and work to the nth degree to come up with a pattern. And then when the pattern doesn't show up, they refuse to believe that it's random. What they do is they look for the error in their scientific endeavor to discover the pattern. We look for patterns even when they don't exist. I'm skipping number 7 for a minute because that's the most important one and maybe the one that we'll spend most of our time on. The conservatism bias is not a term I use, but I will refer to the status quo bias. And in an ideal world, we know that change happens, and slow, incremental change is a good thing. Unfortunately, oftentimes people don't want to see that change happen, and as a result, we get to tipping points where instead of something happening slowly over a period of time, we have a great big issue. And I'm going to spare you my lecture about how the Roman Republic had 2 council, and the 2 council had to agree with each other on steps to take. A no vote overrode a yes vote, but it was a very good way of ensuring that when the 2 council did make a decision to do something a little bit differently, you didn't have people exercising hindsight bias. Now, hindsight bias is not on our magic list here, but every one of us Monday morning has exercised hindsight bias by saying what the Lions should have done on the Sunday before, what play should have been called, fill in whatever team you want. It's always quite obvious what should have been done after it happened. And the right decision is always easy to see when it's already been made. Things are a lot more foreseeable once they have occurred. So we have another thing called the hindsight bias. All of this plays a role in the way we want to present proofs and create the PowerPoints that you are going to use time and time again to make the points that you want to make for the purposes of winning your case. In the classroom, I get to say that the adversarial system is one that allows conflict to grow as if it's in a petri dish, because the search is not for truth. The search is to win. The task is to win. And so let's talk about confirmation bias for a minute. I didn't know what it was when I started talking about it for 2 or 3 years. All I knew is that I had seen a column in the New York Times written by David Brooks. And in this column, he was making reference to a man by the name of Nassim Taleb. So one thing that I knew was that we had one person from Isaac's side of the family talking with and about a fellow from Ishmael's side of the family. And I thought that was kind of neat and cool. Nassim Taleb is the man who coined the phrase of black swan events. For an awful long time, nobody thought there was such a thing as a black swan. So there was no such thing as a black swan. And then one day someone discovers it in Australia. The event changed everybody's thinking, the perception, the confirmation was that there was no such thing because no one had ever seen one. I'm delivering this brief note about black swan events and the David Brooks column, and I hear a voice. It was in an Auburn Hills class. a voice to my left, which means on the right side of the class, the way the students teach. And that student, Amy Marino, said confirmation bias. And I then found out that Amy had a master's in psychology from Yale, and I now learned a term to apply to this bias. Someone comes into your office and asks you to look at their case and then, decide whether you're going to take it. Once you've decided that you're going to take that case, you have an element of confirmation bias. And what it tells us is that from that point on, virtually any evidence, any testimony, documents, fill in the blanks, that is favorable to your position will seem much more logical, rational, easy to understand, easy to assimilate. Whereas any information that suggests to the contrary will be harder for you to assimilate. It will not make sense to you. And a study was done on this. Many of you may have already heard about it, but let's use it for demonstrative purposes now. You take a large group of people, half of whom are strong supporters of the death penalty, and another half are strong opponents of the death penalty. You show all of them identical information, and contained within this peer-reviewed information is stuff that supports both sides of the argument. Common sense suggests to me that when these people with these two diametrically opposing views are presented with that type of material, got some good stuff, got some bad stuff on both sides, that it would move them somewhat closer together. Ain't gonna bring them here or there or there, but it's gonna move them closer together. In fact, what happens is the opposite. And the people who support the death penalty focus upon the material that supports their side. They assimilate that information. The people who are on the opposite side of that issue focus upon and assimilate the material that supports their point of view. And so instead of bringing them closer, it only solidifies them in their contrary positions with each other. My concern about zealous advocacy is that it's sort of a petri dish, not a peachtree dish, as a famous or infamous congresswoman used that term a while back, but a petri dish for growing more conflict. Zealous advocacy seems to me to almost mandate the addition of even more confirmation bias than we might normally have. Lawyers are smart. When I get near the end, I'll talk to you about perspective taking and how we can engage in certain activities to de-bias or to diminish the amount of influence that bias has. But most regular folk don't have that opportunity. I'm very concerned about how clients bring their confirmation bias to the relationship that we have. And so my practical lesson for all of you is, if you got good news to convey it over a period of time. And if you got bad news, convey it all at once. But you need to convey it. You might even want to emphasize some of the bad news a bit more because your client is going to overvalue, because of confirmation bias, the stuff that's good. How do you know if you've made an effort, a successful effort to de-bias some of these potentials with your own client. And I think you'll know that if the client looks at you and says, whose side are you on? To which your reply will be, I'm on your side, but there is this thing called confirmation bias, and we need to keep our heads in the game. We need to understand that the stuff that looks good is more than likely not as good as we think it is. I know that one of the people in the audience, or at least I think one of the people in the audience here, is the son of a dear friend of mine, and he's a singer, and he would tell you that there's a line from a song called "The Boxer" by Paul Simon, and the line is, "People listen until they hear what they want and ignore the rest." Cam, I don't know if that line has spoken to you, but it has certainly spoken to me. People listen until they hear what they want, and then they ignore the rest. I haven't talked about all of these, and I'm not really sure what time it is. I always lose track of that. Is it really 3:53? How much more time do I have, Dave? Chad? Way too much time on this stuff. I apologize.
So we are kind of drawing towards
Okay,
the
that
4:30
great.
program, but because there's
Okay.
not a lot of questions, thankfully we can just move through the program at a
Okay,
rate.
so here's what I want to do then, if we can, Chad. Can you go to the fourth slide, which has the look of the pensive lady on it? One, no, that one. I wrote on that one, what's the likelihood of an earthquake happening? Then what's the likelihood of the earthquake causing a dam to fracture and then a flood to take place? These are heuristics. You know, if you ask that question in Kansas, people are going to answer it differently than in California, where they have a lot more thought about an earthquake that could break a dam and cause a flood. Can we go to confirmation bias for a second and see if a picture speaks better than 1,000 words? You've heard the 1,000 words from me and then some. But in a picture, this tells you a bit about confirmation bias. And we have to work on ways to debias ourselves. Can we skip the next slides, Chad? Fundamental attribution error. This is well documented. And what it basically says is that if I cause something that is either going to be physically or mentally, emotionally damaged to someone, I will have had no choice. I would have been forced to do it. Whereas if you do something that causes me that type of damage, I impute intent to you. That is the fundamental attribution error. We need to think about it. Anchoring, Chad, if we can go to the next slide again, and I really appreciate this. This is what I've spoken to you about on the previous the second slide, and to this I added the influence of things that you just wouldn't think could possibly matter, like the last 3 digits of your cell phone number and your estimate of when Attila passed away. The next slide is about risk aversion and loss aversion. Most people are risk averse, and what it means is that we will take more risk to avoid a loss than to achieve a gain. The scientists who have studied this can actually tell you that most of us need a gain of 1.9 to take that risk over a loss of 1. So you almost have to double the money on the table to take that risk. Now, the way I look at this bias is, if I were the defense attorney on a case and I had put $1 million on the table, rather than just saying that's an offer, I think I would try and frame it in such a way that the person who's hearing that hears that that's money that's in the bank. Are you going to risk that? What did I say, $1 million? Are you going to risk that? Go to trial because you want another 100 grand. Now some people have risk-seeking behavior, but I think all of us attorneys need to recognize that this is a bias which exists, and we ought to sort of measure that with our own clients. I'm not going to suggest that it's going to take $1.9 million to get that case settled, but what I am suggesting to you is that once that person perceives that that's money in the bank, it's going to take a lot more for them to risk losing it at trial. I don't know if I like that, but I know that's a frame that exists. I got way too many things to talk about. Can we go to hindsight bias for one chance here? And here's what I'm going to tell you about hindsight bias. And this is for all of you that think in terms of medical malpractice. When we provide materials for an expert review, we provide the expert with everything we got. One of the reasons we do that is we fear someone at some point in time saying that we've withheld information, etc. I'm here to suggest to you that that's not the way we should do it. And now I'm speaking as an academician. But every once in a while, the things that the academics talk about have some real world impact. I suggest to you that when a physician is asked to review a chart, and note that I did not say on behalf of who, I didn't even say to review it in the context of medical malpractice. I would suggest to you that if you already give that reviewer all of the materials so that they know what the ultimate outcome was, it was a death. Instead of a discharge summary, there's a final summary. Then knowing that has biased the expert. The chart should be reviewed by that expert page by page, test by test, study by study, all in chronological order, if the goal is to avoid hindsight bias and to find truth. I pose that question to a real expert. His name is Itor Dror, D-R-O-R. And Justice McCormick arranged for all of us members of the State Bar of Michigan to listen to his lectures on bias a couple of years ago. And I wrote with him, and I made a suggestion that I just made with you about how we should review charts, and he agreed. His fame has to do with fingerprint identification. And the program he presented showed us how you can bias a fingerprint examiner's decision by saying things to them like, yeah, we've got a confession, or there's 3 eyewitnesses. And those examiners, when they knew that, could be moved from the I'm not quite sure to it's not a match, or to it's a match. Information that they don't need in order to make the determination of whether the fingerprints match. I suggested to Dr. Dror, who's with London College, that's supposed to be a big deal. And he agreed with me that at least from the standpoint of a non-adversarial setting, a chart should be reviewed in that chronology. That if you know the patient died, then automatically you're going to be looking for that first sign that something wasn't right, that something that should have been done, et cetera, et cetera. And that's how hindsight influence can mess us up. Now, I know, Chad, throw a shoe at me or something. I got to be getting short on time. I want to talk to you about perspective taking as one way of dealing with these problems. You have to be able to look at a problem from the other side of the fence. There's two acronyms. Where you stand determines what you see. Write out the first letter of each of those words. And what you see is all there is. So if your perspective is gained by looking at a problem from only one perspective, that's all you will see. And that perception will be your reality. So you have to look at and challenge from the other side. The military has aggressor squadrons that fly against our own pilots to help them find strengths and weaknesses. And I would suggest to you that we need to involve ourselves in that form of perspective taking. When I've talked with Chad on occasion, he has used the term focus group. I tend to use the term mock trial, but the point is that presenting the material to regular people who have not been biased about what side you're on, is going to be an enormously valuable tool to tell you where your strengths are and maybe where some of your weaknesses are. These are things that you can do when you still have time to make corrections, to change direction. Doesn't help us a lot afterwards. The third thing that I want to talk to you about is the consideration of what we call a pre-mortem. Everybody knows what a post-mortem is, right? Why did this person die? Let's go cut them up in the standard Y-shaped incision and see what we can find. Military will call it an after-action report. In other words, if you're out on a patrol and you get ambushed, you write a report about it because once you've lived through an ambush, you really don't want to have another one. So you want to learn from that. Well, in the legal business, I don't think that we do postmortems. What we do when we lose is we file an appeal and tell an appellate court why the judge or the jury or the judge and the jury got it wrong. Pre-mortem is a challenge to your own theories about the case and how they could fail. You could do it with a focus group. And I suggest to you with, I've really given up on trying to say everything I wanted to say. One more thing, and this really matters to me, priming. I'm going to give you an example of that right now that's in the press. It's very material to this country. There was a man who for 8 months before the election constantly said, I'm so far ahead, the only way I can lose is if it's rigged. Time and time again, you heard that. And then you've heard the election was stolen time and time again. That's priming. And it's effective because a substantial number of people without any of what us lawyers would call evidence buy into that. Priming matters. Chad, can I tell one more short story about priming?
Yeah, of course.
Okay, a million years ago, I've got a press case with Nick Rennie. I'm old. That's the way it is. The press was equipped with what were called Possum's pullbacks. You tie a cable to the male part of the die, you run it up over a pulley, goes down through another pulley, and then your hands go into the gloves. The idea is that as the ram comes down, it pulls your hands out. Well, over time, the cables don't work well. They stretch. One person operates it, and that person is 5'4". The next person who's operating is a Marfans, who's 6'3" and has a huge wingspan. They have to be adjusted constantly. In that case, every single time that anybody talked about Posson's pullbacks as being a safety device. And OSHA called it a safety device. Nick objected. The Posson's pullback is not a safety device. Constantly, time and time and time and time again. Probably was occurring at a time when we didn't know that much about priming. Maybe he didn't even know that he was priming. Maybe he was just trying to make a point that they didn't like Posson's pullbacks. But in my hindsight, I would be willing to give him the credit. Prime. You hear it more and more. That's what I got.
What I heard from that, Graham, is that sometimes if someone repeats a lie enough, it can become seen as the truth.
There you go, right? There
Kind
you
of
go.
like that
If Joseph,
election lie, yeah.
well, and if Joseph Goebbels knew as much as behavioralists know today, maybe we'd be doing this lecture in Deutsch, right? But yeah. You want to talk about the power of priming? That's a good example.
Yeah.
Smart, educated, economically advanced, socially advanced, well-educated people in Germany killed 6 million Jews. Priming.
Well, that's
Now
kind
I'm
of a somber note to leave us on, but thank you very much, Graham. It was a very intellectual and stimulating conversation as always. I look forward to seeing you this fall in class. And would a couple of just a quick question. If audience members have questions, when we send out our poll of and survey so that we can learn from and get feedback on the seminar today, is it okay if we include your email addresses and David's as well, so that if there's any audience questions, they can contact you directly?
Of course.
Absolutely.
Certainly.
Yes.
Thank you, David. Are there any final questions from the panel, or for the panel rather? Just a comment. Lee Hornberger from the ADR section says this has been very nice. Thank you, Lee. We really appreciate that feedback. You will be getting a survey in the mail. Your feedback really is important, both on ways that we can improve our programming and different topics that are coming up. I'll give you guys a sneak preview of something that's coming up right now. And that is starting at the next fiscal year for the section, which starts in October 1st. We're going to switch our programming to a lunchtime webinar, 1 hour webinars, the first Tuesday of the month. And so hopefully that'll provide some consistency, and there'll be some special programming and rates as well. And so that calendar will be coming out in just a few short weeks. Until then, I would like to thank our panel, Professor Graham Ward, Attorney David Christensen, the section chair Bob Riley, and again, Matt Hinkle and Madeline Lowry for their significant efforts. It looks like we had a couple more comments before we come out. Both thanking you for the programming as well. Again, thank you everyone, and have a great day. We'll stop the recording of the program now and stop the broadcast as well.